Is the mic working? Can you hear me? Okay. First of all, thank you to the organizers for inviting me to come and speak. My apologies that my talk was TBA. That's a technical reason for that, but also because I wasn't sure whether I should speak about my research or actually speak about some of the recent policy developments in the courts in England and Wales, and how that might actually create some opportunities for more cooperative working between statisticians and the courts. And I'm quite bored of listening to myself talk about my research, so I've opted for the second one. And I think, given one of the comments earlier today about the point of such a wide range of people coming together in one room, being that we've got to deal with quite a historic legal system that's trying to, in some ways, catch up with more modern understandings of probability and statistics. I really did want to talk about some things that people may not be aware of that are currently going on in the courts in England and Wales, probably soon to come to a jurisdiction near you if you're not from England and Wales, or they may already be there. But I think that there are some important developments going on that do mean that there is a door opening for those of you who are statisticians or who work in the scientific area to actually try and address, I know what some of you are very frustrated by, which seems like a lack of understanding within the legal system of your work. So I will just give you a little bit of my background, which is that I carry out empirical research in the law, particularly on judicial decision making, and that's by decision making by professional judges as well as juries. But I also do a lot of work in relation to how the courts operate, using large-scale analysis of data, for instance, looking at all jury verdicts and all defendants and all the Crown courts in this country over a large period of time, looking at correlations between, for instance, race of defendant, background of jury, and things like that. I do large-scale analysis with judges on their attitudes to their work and various other things. And also I do post-verdict surveys with juries. So I do have somewhat of a quantitative background. Like many people who stood up here today, I am not a statistician. So I'm very happy to talk about any of that research after this. I'll be around for the rest of the day. But I would really just like to talk about what we actually know in this jurisdiction. And I say England and Wales. Our Scottish colleague who's here will agree with me that they are two very distinct legal jurisdictions. But what do we know in England and Wales about judicial understanding of issues to do with statistics and probability, lawyers' understanding of that, undergraduate law students' understanding of that, because that's where it starts on that side of things, and juries. And that part of my talk will be very short, which is we have virtually no empirical research that looks at any of those things in this jurisdiction. We have a lot of anecdote, we have a lot of perceptions, we have a lot of very experienced barristers who appear before juries who are convinced that this will sway the jury or that will sway the jury in terms of statistics. But actually there has been no reliable empirical research conducted on that issue with juries in this country. Now, people may cite some other research from other jurisdictions on that point, but we have done a lot of research with actual juries in this country. All the research that we do in the UCL Jury Project only deals with actual juries at court. We don't use students or members of the public for proxies. And none of that research involves, at the moment, involves statistics and probability. We hope to change that in the future. But one thing we have learned is that you can't assume that what a researcher finds in one jurisdiction about juries can be applied in this or any other jurisdiction. You have to do your own research. So we really don't know what judges' understanding is in relation to statistics and probability. Many of you can cite certain cases and say, well, that shows they really don't understand it, but we don't have any consistent analysis of that. Same with lawyers, as I said, same with juries. So that's quite a negative story. So I'd like to move to talk about some of the things that are going on in the courts that is a bit more optimistic and provides some scope for more progressive working on this issue. First of all, it's important to know how do judges learn things. So you may or may not know that there is a judicial college in England and Wales, and judges are not compelled to attend judicial training courses in terms of continuing professional development, but it is now very much expected that they will attend at least 2 courses a year. There are no courses on statistics and probability in the Judicial College, but there are courses that occasionally try to incorporate that. But I can just highlight that as that's an opportunity for the statisticians and the experts in this room to open a dialogue with the people who run the Judicial College. If you're seriously concerned that you believe that judges don't have an understanding of this, David's very helpfully outlined for you what the role is of the judge, particularly in the criminal case, but in civil as well, what their role is in terms of assessing the probative value of your evidence. So, it's an opportunity to approach the Judicial College, to work with them, to perhaps try and incorporate some issues of statistics and probability into existing courses. Judges can choose what courses to take. Chances are, if there's just a course on statistics and probability, it's not going to be the big draw. But there are a range of courses, and I would suggest that in almost all the courses there would be a good reason to incorporate something. For instance, there's in criminal cases, there's the serious crime course. There's a good argument that you could incorporate something into that. A bit of caution there, though, that as you can imagine with budget cuts, the judges' courses are shrinking. The amount of time that they have to attend the courses is shrinking. So that needs to be factored in, I would say, to the statisticians in the room to say, you've got to make a compelling case for why judges could do with this training. I'm sure there is a case, but you need to know that you're kind of fighting against judges who would very much like training, but budget cuts mean that they're having less of an opportunity. Lawyers, this current development going on, as you know, barristers and solicitors are required, or up until now have been required to do a minimum number of CPD hours every year. And there were certain specified activities as well that they had to have training in. Now that would have offered you a very good opportunity to convince the Bar Standards Board or the Solicitors Regulatory Authority that some of the crucial required courses for lawyers should involve statistics and probability. There is changes going on both for solicitors and barristers which are loosening those requirements for CPD, which means that there are no longer going to be required topics and no minimum number of hours. It's a kind of self-assessment, self-declaration that you've done various things. So for all the lawyers in this room, I'm sure that today's event will count towards your self-declared CPD. But that means, again, as statisticians, you're facing a challenging situation there with lawyers. You've got to make the case that lawyers actually do need this training. But on the positive side, I was thinking there's been a development over the last 5 or 6 years for the criminal bar. There's something online called the Advocates Gateway, which David may well know about. This has developed a series of toolkits for lawyers, particularly barristers, appearing in criminal courts. It was designed initially to provide guidance to those lawyers on how to question vulnerable witnesses, how to deal with individuals who were not being dealt with properly in the courts, some aggressive questioning of children or female complainants in rape cases and so on. But that whole process has created a whole series of toolkits that are now online, freely accessible to the public. If those of you who've got your laptop open, you can Google Advocates Gateway and see what the toolkits are. And I was thinking that that's an opportunity as well for statisticians to work with the Advocates Gateway and to propose creating a guide for lawyers about the use of statistics and probability in cases. And I think that would be an interesting first step, and to see what the response would be. It's a very open group. Obviously, it's not about vulnerable witnesses per se, but I think that is one opportunity. Law students, those of you who are from other jurisdictions, in England and Wales, are undergraduate law students, because this is where it all starts. Those are our future lawyers, those are our future judges. In an ideal world, they would have training in statistics and probability at an undergraduate level, if not before, but I won't go to primary education or secondary education. One of the difficulties in this jurisdiction is a law degree is an undergraduate degree, and it is highly regulated. So there is no choice of subject in the first 2 years. The students have to take very black letter law courses. In their third year, they do have some options to take some additional courses, but I'm not sure whether there is any law school that would offer an option in statistics and probability. There's an opportunity for you to get involved in that. Many of the statisticians in this room are members of academic community, so it is possible to work with your law schools on that. But there is some good news, which is the Nuffield Foundation recently launched a £20 million project across the UK in 15 different universities that's called Q-STEP, and it's designed to increase quantitative analysis at the undergraduate level, particularly within social sciences, but some of those 15 universities have included law faculties. So that's, again, another entry point to begin to get some training for lawyers on statistical analysis. But where I really want to end is in relation to juries. So much of what we end up talking about in relation to this issue is about how can we possibly get 12 uneducated, which is how it's often described, people, certainly not legally educated, to understand the complexity of statistics and probability. And as I said, so far in this jurisdiction, we have not yet been able to look at this issue of how well juries understand and apply the statistical information and the probability information that they're often given in cases. But there are some recent developments going on. Dave mentioned one of them at the end of his talk. There are some major changes going on in the courts in this jurisdiction, which I think do provide a real opening for much closer working between statisticians and the courts and the judiciary. The first of it is that there is now a major program to digitize the entire court process. And that means everything from, basically going paperless in courts. Some of you will be from jurisdictions where this has already happened. But in this jurisdiction, this is a very big move that's happening. What that means is not just are the case files digitized, but this is moving to the complete digital presentation of evidence in court. I've woken someone up. Now, this, it was very interesting. We saw some. Well, that would be a challenge for you to think about. People will be appearing remotely on screen. More people will be. It does happen from time to time, but there was 2 years ago there was a review of the efficiency of the criminal courts, led by Lord Justice Leveson, and that strongly argued in favour of much greater use of remote evidence being presented in court, so people not having to come into court to give their evidence, but to give their evidence and be cross-examined on screen. But what I'm talking about more is visual presentation of evidence to the jury. So this is going to mean that lawyers are going to presumably start using PowerPoint and various things more often. But the really radical change, there's two radical changes going on with the judiciary. It's the judiciary now asking, how do I direct the jury and sum up the case using the screens that are being used in court for everything else? And judges are now asking for training on the use of PowerPoint in various things. So you can see what stage we're at with that. But I do think that offers an opportunity. As many of you will know, judges do direct the jury in relation to DNA evidence and various other things. That direction now, for almost every single judge in the Crown Court, they are moving towards written directions. This was the first radical change. Prior to this, it was just all orally delivered, and you could just cross your fingers and hope that the jury would remember the 2 days of judicial directions and summing up of the case that might have occurred in a very long, complex trial. Now judges are routinely using written directions. We did research with actual juries at court in this jurisdiction to show, perhaps not surprisingly, that those juries who had written directions were able to recall the law that they were supposed to apply much better at the end of the trial than those who were not given those directions in writing. That has resulted in judges changing the way that they direct juries. But those written directions are now going to have to be written directions that are also somehow on screen. So I think that provides an opportunity for the scientific community, statisticians, to begin to work with the judiciary as well as lawyers to work with the statisticians and scientists about how is it going to be best to present this evidence to the jury if it's all going to be on screen. There's also recently, there's something called the Crown Court Compendium, and that is a book that basically is used by the Crown Court judges, and it provides them with almost all the directions that they need to direct the jury on any case. And I think that's something that has come out in the last year. It will be being revised on an annual basis. And this, I think for all of you, if you're interested in this kind of thing, you need to look and see what it says in that compendium about what the judge should be telling the jury about different aspects of the evidence that may relate to DNA or statistics, probability, and so on. If you think that there are some things that are fundamentally wrong, you need to be working with the judiciary on that. So that's not the court service, that's a separate thing. It's the judiciary is in charge of this. And there is an advisory group that works on the revising and the editing of that compendium now on a regular basis. So I think that also provides a good opportunity to work more closely. And I think really finally I want to pick up on something that David mentioned at the end. In this jurisdiction, yes, the judiciary has agreed that there will be now information guides for juries about certain fundamental things. It might be about mobile phone data or phone masts and how that information is collected and how it's used. It might be about DNA, it might be about probability, but things are moving even further, and this is not sort of officially announced yet, but the judiciary is moving to consider the creation of short films to be shown to the jury that will be, in effect, the guides but on film. Now this has been used in the US. I know particularly the US federal courts use it for things like patent cases to try and explain to the jury what's a patent and how does it work and where do the problems arise with it. So it's not unheard of in other jurisdictions. But I think something like that provides a great opportunity for scientific community and statisticians to try and work as closely as possible as you can with the judiciary. If you know they're going to create a film that's going to be shown to every single jury in which DNA evidence is is presented to court. The judiciary will rely as much on you as you on them to make sure that the information in there is correct. So it will start probably with the written information guides, but I know for certain that I'm involved in the development of one of the films, not related to statistics. But I can easily see how the written information guides are going to move to film guides, especially as we're now into the digital courtroom and everything has to be presented on screen. So I've done the thing that we're no longer going to be doing in court, which is I haven't used a screen and I've just stood up and spoken to you. But I hope that I'd like to, at least think that there is some positive opportunities to begin to bridge the gap between the statisticians and the lawyers and the judges and the juries. And there is a huge role for you to play in ensuring that the correct information is presented, particularly to the juries. And I think the real challenge is going to be, and this is the work that I do, is how is that information presented in the most effective way so that they are actually comprehensible tools that juries can use in order to make an informed decision, so David's not going to be so worried about the basis on which the jury made the decision. Okay? Thank you.
Thank you. In fact, the Royal Statistical Society Statistics and the Law section at our last committee meeting had approaches from a wide variety of people precisely about these guides. Thank you, Carol. It's extremely useful. Bernard.
Just to add, the Royal Society and the Lord Chief Justice and so on are working on primers, which should also be added. This is the idea of definitive documents setting out the science, and they're working on, is it gait analysis and DNA are the first two, and so that's another project, if anyone wants to know more about that.
And the Royal Society of Scotland's part of that, yeah.
And the RSS are part of that as well.
So that's good news.
Yes.
There is dialogue happening.
Oh yes, there is. It's taken a while, but it's...
Yes.
But I think one of the, if you look at the work that's been done in the medical field, I mean, David Spiegelhalter is supposed to be here, but I don't think he is. He's done some fantastic work on presenting issues around mammographic screening. That's leaflets that's sent to every woman in the country or something.
There should be a talk about that on Friday.
There is, and I think the idea that we should not patronise, or we should actually understand that if you say is 1 in 100 a big probability or a small probability, that sort of thing. What does it mean? We should understand that we don't.
Yeah, there's already a thing.
I'm just going to follow up on that to say that where my research comes into this is that I'm a very strong proponent of these are great ideas, but they need to be tested with actual juries at court to test their comprehension, not just like we watched them, we thought we could understand them, they seemed good. That's the level we're at the moment. It's based on assumptions about what people will understand and what they won't.
Don, yeah.
Well, when it's about teaching people to understand stuff like likelihood ratios and stuff, we're doing some experiments currently on that in Lund, and we've tried to, for example, compare if you simply try to teach someone verbally, if you have slides with just words or numbers, or if you use images, for example, that if you want to explain, okay, what's 1 in 50, then you actually have 50 small little guys, and one is red and 49 are black, or stuff like that. Or even that the teaching involves people doing something physically, picking a billet out of a bowl with 100 billets to kind of get a feel of what it's about to have a 1 in 100 chance and stuff like that. And it seems to us that laymen catch on much more quickly with images and when they do physical things than if you just explain it to them. I don't know if you have similar experience.
Well, it's a really interesting issue, but this is a classic case where there's people who probably aren't in this room who could talk about this forever, because there's been a huge amount of particularly research on adult learning. And many of us have probably even taken the test without knowing it. How do you like to learn? Some people like to learn by reading, some people like to learn by doing, some people like to learn or learn better visually, and then some of us work best by a combination of all of them. And from my understanding of the literature on adult learning, the majority of people learn best through a mixture of different approaches. And that's what we haven't done historically in court. It's all been an oral tradition. And so the first big change was judges presenting written directions. And that's only happened in the last 5 or 6 years. And I've got one Crown Court judge out of several hundred who's the only one who refuses ever to use written directions, but he's shortly to be retired, which is good news. So it's moving in that direction, I think.
We have one last quick question, I hope, William.
I'm wondering if the digital courtroom will mean that the transcripts of expert testimony and the exhibits the experts use and the judge's instructions and so on will be available to the public, or will at least be available to researchers who wish to look into this?
Interesting. Well, the digital courtroom does not translate into everything being a public document. Things are behind firewalls, and there are only some parts of the case file that only the judge can see, some part the prosecution will see, but defense, so on. So there are firewalls. But you raise a really important issue, which was on my notes that I didn't raise, which is another place where statisticians can really assist the courts, which is in advising about the collection of data and then also the analysis of data. And the Ministry of Justice does have a small analytical services department with some statisticians and so on in it. But one of the huge problems that all researchers face in this jurisdiction in relation to studying the courts, and there aren't that many of us, so it's a kind of new field, is the quality of the data. Criminal courts are actually much, much better than the civil courts. Civil courts are terrible. So, but the decisions about how data is recorded and then its availability and so on is just done ad hoc. It could do with some expert advice.
That's very nice. Thank you very much. Thank you, Carl.